Womanjaka, which is Wurundjeri for welcome. I'm Carol Grimshaw, the Chair of the Electronic Wills and Online Witnessing Committee. I'd like to acknowledge that this webinar meeting is being held on the traditional lands of the Wurundjeri people of the Kulin Nation and the lands and peoples of Aboriginal nations on whose land we all work, live, learn and play. And I pay my respect to elders both past, present and future. The Electronic Wills and Online Witnessing Committee also recognise those whose ongoing effort to protect and promote Aboriginal and Torres Strait Islander cultures will leave a lasting legacy for future elders and leaders. The EWOC and its parent, the Australasian Cyber Law Institute, is delighted to welcome an esteemed panel comprising His Honour Justice Riordan, Chief Judge of the Commercial List of the Supreme Court of Victoria, and appointed to the court on 10 March 2015, and Registrar Kate Price, Registrar of Probates of the Supreme Court of Victoria since 3 December 2020, and with a 15-year career in the court working around probates prior to her appointment. They both join us this evening to discuss the Justice Legislation Amendment, open bracket, System Enhancements and other matters, close bracket, Act 2021, which commenced operation in Victoria today. For our purposes, we'll abbreviate that to the Justice Act for this evening. We also welcome our special interstate guest and friend of EWOC, Chris Herrald, partner of Mullens Lawyers in Queensland. Chris is a specialist in wills and estates and is generously taking time out from her Anzac Day public holiday to talk with us today about the progress made in Queensland in electronic probate filings. Chris is also chair of STEP Queensland and will perhaps talk to us about just how far advanced Queensland is compared to us. We'll first hear from Registrar Price, who will speak about the Justice Act and her experience of applications during the COVID regulations. We will then turn to His Honour Judge Riordan to understand his experiences of court in the COVID period and His Honour's views about the introduction of the Justice Act 2021 today. We understand that there's been some broad experiences as between both parts of the court. Before moving on to the Town Hall and our fabulous audience, Chris Herrald will round out our discussion panel with her perspective on just how advanced Victoria really is and her experience as part of a special committee that helped pilot the introductions of electronic filing in Queensland probate. We'll be addressing all of your questions at the end of the panel. And if you haven't had an opportunity to register your questions, we'll be delighted to receive those in the chat. Registrar Price, thank you very much for joining us this evening.
Thank you, Carol. Thank you so much for inviting me to talk again. It's always a pleasure to come and talk about these sort of things, and particularly where it gives me an opportunity to actually talk to the profession and provide some guidance, which I know that they're very keen to receive at the moment, particularly with the changes to the legislation. Also, thank you for bringing up the idea of saying the Justice Act, because I was sort of thinking it's a bit of a mouthful to keep saying it over and over again, so I appreciate that a lot. I think it's amazing that you timed this to be on the 26th of April 2021 when the Act is actually coming into effect with respect of a lot of changes that have been made. The significant changes I want to talk about today are obviously to the Wills Act 1997, but I did just want to start by just reminding people that the other significant changes that come into effect today are permanent changes to the Oaths and Affirmations Act 2018. Which now allows the electronic audio-visual witnessing of affidavits. And I just want to remind everyone that now is the time to update precedents. A lot of solicitors and members of the profession created precedents around the time that the regulations came into effect, allowing the signing of affidavits. And they will obviously need to be updated to make reference to the correct information as required under section 27(1)(a) of the Act, as it's been amended by the Justice Act. That's all I'll say on that, because I know that you'll all go along and have a look at your precedents now and make sure you're complying with the new requirements under the Act. What I want to talk about mainly is the changes to the Wills Act 1997 and the position we are now in relation to being one of the very rare jurisdictions in the world that allows the electronic signing of wills. There's a couple of jurisdictions around the world that have taken that step. So you've got a couple of states In the United States, you've got places in Canada, some places in Canada you're able to make electronic wills. But we are one of the first common law jurisdictions which actually allows the electronic signing and witnessing of wills, which I think is a massive step, and it'll be interesting to see exactly how that works under the Wills Act 1997. What I did want to briefly talk about first before I talk about the changes to the Wills Act is basically given a bit of an update in relation to electronic witnessing that's happened under the regulations. Obviously, you can't witness under the regulations anymore, but I think a lot of wills were probably made during the time that the regulations were in effect, from April last year all the way through to this year. So we've had 12 months of the regulations. In terms of the court's perspective, we've had so far 14 applications that have been filed in relation to wills that have been purported to comply with, being signed in compliance, well, in purported compliance with the regulations. Unfortunately, none of those have actually met the requirements of the regulations yet. So the reason I just wanted to raise this is because if you have made any electronic wills during that time, it may be worthwhile just revisiting those wills to make sure that you've actually complied with the requirements of the regulations. And if you have any doubts whatsoever, I just recommend potentially getting your clients back in and re-executing those wills so that you can make sure that they comply with the requirements for an electronic will. There's two things that have been most significant with respect of non-compliance. The first is the Section 41(5)(c), which of the regulations, which required that the statement by the witness that the witnessing of the will is done via audiovisual link is actually done when appearing via audiovisual link. So if you completed that statement and put it into the will before you actually sent it around to everyone for it to be signed, then unfortunately you're not actually meeting the requirements of the regulations. And I know that sounds really particular, but our role at the court is to assess whether or not you've complied with legislation, and that is a specific requirement of the legislation. I've had solicitors contact me and sort of say, well, but you know, do I really need to have done that? And unfortunately, under the regulations, you do have to have done that for it to be a validly executed will. The other one is Regulation 41(5)(f), which requires the final statement after it's been witnessed, that final statement by the testator or a person who's been directed by the testator to sign regarding compliance with the regulations. And again, that hasn't been done on all occasions. There's been several instances where one or the other hasn't been done in terms of Regulation 41(5)(c) or Regulation 41(5)(f), but none when both have actually been complied with yet. So it's just two things that you really need to look out for if you have done any wills pursuant to the regulations. I think the benefit is obviously that in Victoria, we have Section 9 of the Wills Act. So all of those wills, even though they haven't complied with the regulations, they've still been able to proceed. So it's not the end of the world, but it does make it a little bit difficult because you're relying on Section 9 of the Wills Act to proceed as an informal will. And in those situations, you potentially need to, or you do need to get medical evidence, and you potentially need to appear before the court, depending on whether or not there's minors that might be affected and the value of the estate. So they're two things that are really important to check over to make sure that you've complied with the regulations if you have done any wills during the last 12 months. Now, luckily, before the Act was actually changed, this feedback was provided to the government when they were drafting the new bill and the new Act, the changes to the Act. So they did take that feedback into account. So the court gave feedback that it appeared that the solicitors were finding it very difficult to comply with the regulations or read the regulations and understand what the requirements were. And I think if anyone has had a look at the permanent changes to the Wills Act made by the Justice Act, you'll see that they're a little bit more straightforward and compliance should be a little bit easier under the permanent changes to the Act. The Act introduces what's called the remote execution procedure, and that's the new Section 8A of the Wills Act 1997. I should just mention, if you have a look on the legislation website today, you can download the new version of the Oaths and Affirmations Act, but the new Wills Act hasn't been prepared and uploaded yet. So just hold off, maybe tomorrow or the next day, it might be available online. But once you get a chance to get that new version of the Wills Act, I recommend downloading it as soon as possible, and familiarising yourself with the new section 8A, which is the remote execution procedure. Now, I'm in a bit of a difficult situation here because as the court, I can't provide guidance in relation to how you comply with legislation, because our role is to assess whether or not you've actually complied with legislation. But I think what I wanted to do is just bring your attention to a couple of things and a couple of the requirements under the new remote execution procedure, and maybe just give you a few questions to think about, some things to think about that might make you think about how you might be able to comply with the legislation in a way that makes it easiest when in 20 years' time, someone's coming along to actually seek probate of the will, the electronic will. The first thing is there is a requirement for a special witness. Under the Act, those special witnesses at the moment are mainly legal practitioners. So an Australian legal practitioner can act as a special witness. It can also be a justice of the peace, but I very much doubt there'll be many justices of the peace that decide to do that. So the majority of times it's probably going to be an Australian legal practitioner that acts as a special witness. If there's not a special witness, then a remote execution procedure can't go ahead. And I think that was probably done because there were some concerns about potential fraudulent activity, potential for undue influence, and the idea of having that special witness in there is to make sure that there's a legal practitioner who's able to explain the consequences of doing an electronic will, and also to make sure that that legal practitioner is still satisfying themselves in relation to the usual things such as that the person has testamentary capacity. The other thing that I think might cause some issues is the fact that there's a requirement that all people, all the persons be in Victoria, so that's the testator and the witnesses, and also that all steps have happened on the same day. And on the face of it, if your will precedent, for example, doesn't have anything about where the will has been signed, then there's probably going to need to be evidence in the future when it comes time to probate that will, to show that all the persons were actually in Victoria. So it might be, for example, that if you do decide to do a template will for electronic wills, that you decide that you put in the place that it's actually been witnessed, so the place that each person is when they're actually signing or witnessing that will. And that may just help down the line, as I said, when 20 years' time, when someone goes to probate the will. The same goes with the date, obviously. If there's any issues at all, it's probably best to have the dates there so that you can actually make sure that the dates are on the will. Sometimes there's, depending on what software you use, there will be a track record of what's happened and where it's happened. So things like DocuSign, for example, show very clearly what the dates are. But I don't know if anyone else has had this experience, but sometimes you can have the DocuSign information incorrect because it thinks that you're in America or it thinks you're in a different time zone. And that can, obviously, if it takes a couple of hours for you to do that process, then it may be that that information ends up being incorrect because it has a completely different time zone that it's using and it's gone over from one day to the next day. So that's just the sort of thing that you probably need to be mindful of, and making sure that there's some sort of evidence that shows that it's all been done on the same day. The other thing that I think might cause some issues, or sort of some people might not realise, is a special witness always has to be the last person to sign the will. Even in circumstances where the special witness is in the room with the testator when they're signing the will, they still have to send it to anyone who's appearing via audiovisual link and then get it back and be the last person to sign that will. So something to be mindful of, even in situations where they're together, where the testator and the special witness are together. I think the other thing that will probably, I can't really speculate on, because I think it's probably going to have to be something that's decided by a judge of the court when and if it happens, but there is a requirement that you have to be able to clearly see the electronic signature being made. And I think it's probably up to each solicitor to decide whether or not sharing screen would basically comply with that requirement, or does it mean that every person who's attending, either as the testator and as the witnesses, needs to have two devices so that you can physically see, like you can actually clearly see the person who's as they're making their signature, not just via a shared screen. So those are the sort of things I think will have to be thought about. From the perspective of the probate office and the court, there's two things that have sort of developed over the time that we've had electronic wills, and I think they'll probably continue. The first is a requirement for an affidavit of due execution. It's quite common practice within the probate jurisdiction to require an affidavit of due execution anytime there's a departure from Section 7 of the Wills Act, because Section 7 is quite straightforward in terms of, together with two people, anytime it's something like it was read over or it was translated or it was signed by someone else like a marksman, anytime it departs from that straightforward type of execution, we do require an affidavit of due execution. And I think this will probably be the same. I know that some practitioners have adapted a practice of creating an affidavit of due execution at the time that they actually do a will that requires due execution. So for example, if they're having a translated will, they'll do an affidavit of due execution at that time and store it with the will, so that when it does come time in the future to assess whether or not that execution has happened correctly, they've already got the evidence there to be able to prove it. It's not an issue if it's like 6 months or 12 months later, but I know for a fact that we're the 1960s and the 1970s. So you can imagine in 40 years' time, if we're assessing whether or not someone's complied with the Act, it'll be very difficult to do so in circumstances where solicitors might have moved on. The special witness might no longer be in practice and might not be able to be tracked down. So it's just something to think about whether or not you want to do that at the time that you're actually witnessing an electronic will. And in terms of that, that affidavit of due execution would need to address all of the requirements under the Act. So they would actually go through and say, this is the step we took, then this is the next step we took, then we took this step, then we took that step, so that it could be seen that the compliance with the Act has actually occurred. The other thing that I think that we've adapted, where we've had purely electronic wills under the regulations, is requiring the original will to be filed. I think a lot of people probably have questions about what is the original will. It's a bit clearer, and it was actually a bit clearer under the regulation which the original will was, because it was the final version that was signed by the testator. In this circumstance, it's still fairly obvious under the Act that the original will is the one that has actually been signed and endorsed by the special witness. What's an original electronic document is a bit difficult, because as soon as you make a copy of that document, then it's no longer an original, it's a copy. But what we've been requiring at the probate office is for any electronic will to basically be filed on a USB without any renaming or anything like that. So basically a straight drop from the file straight onto the USB, so that all of the metadata and all of the information of the file is still preserved and can be investigated if anyone needs to investigate it into the future. Those are practices that we've obviously adopted to the electronic wills that have been regulations, but I think that they'll probably be similar under the Act, and the changes to the rules will be considered by the Rules Committee in relation to those, potentially making those requirements a permanent requirement. That's something for the Rules Committee to determine whether or not those changes need to be made to make it clear that they're requirements in these situations. That's probably...
Apologies, you just dropped out for a moment there.
Yeah, it's really funny because I'm at the court and usually our internet connection is quite stable, but
yes, I
think something must have gone wrong. So what did you last hear, Carol?
I last heard about the electronic will to be filed on a USB. That was the last full statement that I heard.
Yeah, so I just said after that, just be mindful that the Rules Committee may decide to make some changes to the rules to reflect those practices that have been adopted. And just as usual, keep your eyes and ears open for any changes that come through in relation to rules as a result of the changes to the Act, the permanent changes to the Act. The final thing I will say, and I'm happy to obviously answer any questions that people have, but I don't want to spend too much time just talking to everyone. The final thing I'll say, and I touched on this earlier, is just to remember to download the legislation when it becomes available and make sure you're working off the correct versions of the legislation. and to update your precedents, because we want to see affidavits, if they've been witnessed via audiovisual link, we want to see those affidavits, the jurats of the affidavits updated to make sure that they actually reflect what's happened and the authority for, and make sure it corresponds with the requirements under the Act. Thank you, Carol.
Thank you, Registrar Price. Wonderful as always, very informative. I'm sure that everybody will be looking out for the full Act, Full Wills Act when it becomes available, and for the full Oaths and Affirmations Act when it becomes available, and updating precedents lickety-split. So I'd like to thank you very much once again, and let everybody know that, of course, we'll be directing questions to Registrar Price at the end of our panel. Your Honour, Judge Riordan, if you would like to, I'd like to thank you very much for joining us this evening. We're delighted to hear your thoughts on the Justice Act.
Thank you, Carol. What I might do, if I could, is share the screen. I hope you're able to see that what I'm going to talk about. The Justice Act has as its main purpose to amend various courts and justice acts to provide for the ongoing operation of certain processes and procedures implemented during the COVID-19 pandemic. For just over 12 months now, the Commercial Court has been operating almost entirely virtually as a consequence of the pandemic. During that time last year, we were able to actually improve our throughput of cases from the previous year, despite the fact that we had virtually no live hearings at all and had to adapt to a new system. What I wanted to talk to you today, because Carol said that I could tailor the event to my needs, is to identify the changes that we had to adopt last year to do trials and hearings virtually, because we're at a point in time right now where what's being contemplated is reverting to live trials. But we have learnt so much about the advantages of technology and so much about the other ways we might be able to do things. And we're convinced that there are ways that we can make the court system more cost effective and more generally effective by picking up some of the lessons that we've learned. What I'm particularly interested in is feedback from members of the profession as to things that they think we should retain from the practices that we've adopted during the last 12 months. So in terms of practices, the first thing is that in the Commercial Court, we have intensive case management. And all of that case management has gone from live hearings to virtual hearings. And the first thing we changed was that previously all of our live hearings were, say, at a particular time at 10 o'clock on a Friday, when all of the cases for management would come on before the court and they would be dealt with during the course of the day. As a result of the pandemic, we started making appointments, and so that each matter was given its unique time, and whilst plainly enough from time to time we'd run over, pretty much effectively we were able to deal with matters on the basis of an appointment. The cost savings should be pretty obvious, that it meant that a lot less lawyer time was involved, and people could judge their days to fit in with the appointment time. Again, interestingly, there was feedback from people saying that there was a reduced opportunity for those appearing, the advocates appearing, to have a discussion outside of court while other matters were being dealt with. Also, it's thought that there was a less opportunity for people to sit in court and be, if you like, educated as to the court management techniques and to learn how the court tends to expect practitioners to prepare their cases. So it's one of those things, whether or not we should continue it is one of the things appointments is one of the things we'll need to consider. We started giving more thought to what we will really try to achieve at particular case management. So sometimes, for example, especially early, the person who prepares the pleadings really needs to be there, because there will be likely to be searching questions as to what's the real defence to this case, because the defence may not make it very obvious. And in terms of trying to get to the real issues, it's critically important that the parties who know most about the case are in court and are able to address pretty specific and challenging questions, so that we can manage and massage how, in fact, the case will be conducted or prepared to ensure that the real issue gets exposed. On other occasions, though, it might just be that there's been non-compliance and we need a rescheduling of a hearing. And that would be most commonly best done by normally the solicitor who's got it in hand and might know when the experts would be available to prepare their reports or other matters. Likewise, whether witnesses are available, often the solicitor would be more appropriate. Those sorts of features indicate that it's another advantage in the court communicating to the parties what the nature of the management is likely to be, so that the proper person can be available. But online hearings will often mean that both the solicitor and the counsel, or possibly senior counsel, will be available. Whereas with directions days, often for example, if counsel is briefed, the instructing solicitor won't bother turning up because it's a day out of their life. Much less involved if in fact all they're doing is working away until the particular case comes up on the screen. So that has real impact on the ability to have everybody available if different questions come up that might be better dealt with by the solicitor who's in touch with witnesses or otherwise. The advantage for regional interstate practitioners, we've had a lot more interstate practitioners appearing during this time because they don't need to fly down to Victoria to appear. We've heard quite a bit about the convenience of lawyers with childcare responsibilities. And the other thing that can occur, because these are streamed, all of these hearings, clients who don't normally come along to case management hearings can easily tune in to hear what's being said. It can be very informative for a client if they're listening in, because judges tend to give a lot away about what they think about a claim or a defence in the course of a case management hearing that the client might be very interested to hear. But very rarely would clients come in to spend the day sitting around for case management hearings. And it raises the question of whether or not we should have hybrid hearings, which what I mean by that is whether some might appear by video link and some might appear live. Those sorts of things are the things we're going to have to deal with. Interlocutory applications, to move it along, give rise to similar sorts of questions. They have some other advantages for us. They reduce courtroom pressure. That is that we've only got a limited number of courtrooms. And of course, if we're doing it online, we don't need to take up a courtroom for a day. Similar convenience for lawyers with childcare responsibilities, similar cost savings for interstate and regional practitioners dealing with interlocutory applications that way. Similar advantages for streaming, that often they won't come along, clients, to interlocutory applications, but it's very easy for them to get online and watch the streaming of it. Urgent matters can be dealt with much more easily. The Supreme Court of Victoria, and Commercial Court in particular, has a duty judge online 24/7. There's always a judge online, and the fact is that judges can put themselves in waiting for their duty to come on. They can be at a holiday house and wherever they might want to be, as can the lawyers. If an urgent application arises, the fact that they wouldn't need to come into court is a significant advantage. Again, we'll need to deal with the question of whether in the future we allow, or parties are comfortable about allowing some people from interstate, for example, to appear by video link and others to appear live. Certainly, it'd be interesting to see whether the same amount of interstate hearings continues. We've had people link in from Moscow for purposes of case management conferences, something that really we just hadn't dealt with before. Trials was very interesting because whilst the commercial court has had online electronic filing for some years, but all of a sudden many of our judges who have been always wanted hard copy court books, hard copy lists of authorities, hard copy transcript, have really had to adapt and did so remarkably well to enable the court to continue to operate. And so all of them have gone, in that sense, substantially paperless. Some will want to revert to paper, no doubt, but I know that others, both in the profession and on the bench, have discovered that, for example, electronic transcripts are a very good way of dealing with things, and electronic authorities, electronic court books have just become the norm. Plainly, witnesses giving evidence from home and work, the sorts of questions of swearing and affirming affidavits, identification of witness statements, the sort of thing that the Act deals with, Justice Act deals with. We've found cross-examination with the Zoom application was really very effective. It's quite interesting from a judge's point of view because you bring up the person live and you're seeing them much closer than you normally would in a courtroom, where much of the time you're looking, if not the back of their head, certainly the side as addressing questions from counsel. Enormous advantages, and I was mentioning to Kate Price before, international witnesses, especially experts, much more available if they don't have to fly out here, and obviously the cost savings is dramatic. We've dealt with concurrent evidence between 4 and 5 witnesses at a time on Zoom, and I have to say it may well be a better way of dealing with them than having them sit effectively in a jury box to deal with their different responses when giving concurrent evidence, which is very common these days. Professional witnesses, not so much, but medical witnesses I know, very much encouraged by the fact that rather than cancel a day's surgery, if they can be fitted in at a particular time at midday for their hour of evidence, they can get on with doing their important work. And the truth is, the experience has shown that their evidence and the cross-examination by the Zoom link can be just as effective, especially for someone like an expert witness where normally credit's not going to be an issue. It avoids this whole question of witness unavailability. The case can't go on, I was told, because one of the witnesses will be, you can't list it for them because one of the witnesses will be in Western Australia in Kalgoorlie. And I said, well, Kalgoorlie's got a very good Wi-Fi system. It's just not really a problem at all. And it completely removes that whole question of the difficulties in trying to make sure that all the witnesses will be available. The odd witness, maybe not the critical witness, but the odd witness being dealt with virtually, I think is something that we will want to retain rather than have to move whole trials. Now, I think live streaming enhances open justice dramatically. If you haven't tried it, the number of times you could, if you find a case that's interesting, the press obviously find it a very efficient way of being able to have a look at what's happening in court while still working on other things, allowing it to happen in the background. Interested parties can observe. There are issues about witnesses being out of court, but they're matters we can deal with. Finally and generally, the savings, of course, with all electronic filing and service, without paper, having to serve matters by paper, the efficiencies become obvious. Affidavits signed and witnessed electronically, admitted in circumstances where sometimes non-compliance are real efficiency. We are changing the rules about affidavits to get rid of separate exhibits, because when you're looking at something online, trying to go through the separate exhibits is a nightmare. Much easier to have one lump of exhibits, all paginated, and you can, whether you hyperlink from the affidavit or just go to the PDF page number, much more efficient way of doing it. We can mandate hearings on the papers. We've adopted a system of electronic signing of orders or judgments. For another day, we can talk about how we'll be able to improve that with some more software in the future. Virtual mediations, which are a big part of keeping cases moving in our court, have continued and the mediators report to me, the associate judges and registrars, that they've become, after a slow start, very effective at putting people in waiting room, in breakout rooms and visiting them and dealing with it. Certainly, the advantages of face-to-face mediations can't be underestimated, but the ability for interstate people and international people still to be present at a mediation, albeit by Zoom, is a great advantage to making sure that the person responsible for the decision can be still involved. So what I'm interested in now, or if somebody would later want to contact my chambers, I'm very interested in what people think about some of those things that would be well to retain, or for that matter, things that they would be very keen to get rid of at this critical point where we are now moving back to live hearings. Thank you, Carol. That's what I wanted to say.
Judge, thank you very much. It seems like the experience in the court has been, on the whole, very positive, despite the challenges that it's faced in the commercial list and the other lists. Perhaps we might have a conversation at another time about the EWOC assisting the court in preparing or providing to the profession a questionnaire, so that we can gather some information on the processes and the thoughts of the court, as well as, and convey those to the, or be a communicator of information between the court and the profession. Certainly anybody who has questions of Judge at the moment can do so in just a short while. Right now, we're about to hear from Chris Herrald. Chris is the partner of Mullens Lawyers and has been working in wills and estates as a specialist for some time. She is a STEP Queensland committee chair and has participated in a program that assisted the current Queensland Justice Department, or the Department of Courts, to work through any technical glitches that might have occurred in the implementation of the digital platform that is now Queensland Probate, or Probate, the Queensland Supreme Court. I'll welcome you. Thank you.
Thanks, Carol. I must confess, after listening to Judge Riordan and Registrar Price, I do feel like that, you know, Queensland's really only just beginning its electronic journey. And so I'm not entirely too sure how I can, you know, all I'll be doing is just letting everybody know what the current experience and feeling is in Queensland, because I'm certainly really interested in if there are things that we could be doing in Queensland that our counterparts south of the border are putting in to increase efficiencies. That would be good. Judge Riordan mentioned e-filing for commercial matters. I think the words you used, Judge, have been around for quite some time, or a number of years. Well, as of about 2 weeks ago, the only documents that are available in Queensland for e-filing are applications for grants of representation. So, grants of probate, grants of letters of administration, they're the only documents that are currently available for e-filing. Mullens Lawyers was one of a number of firms that assisted the court with their pilot program. So my experience was sort of helping the court iron out the kinks of their online filing system, and I'm really hopeful that they will be rolling it out for other practice areas, obviously, than my practice area of wills and estates. So the process, the experience that we had was really excellent. I think you had Julie Steele in one of the last or recent events here, and she made the comment, because I emailed her about it afterwards, was that from the back end, she thought it was quite clunky, but from the front end, the user experience, we've only had a really easy experience. We have found that it's a pretty seamless process. During the pilot, there were a few issues with, for example, because of how straightforward it was, I could file an application for a grant of probate and actually have the grant issued later that day, effectively as soon as the original will had been delivered to the court, which for a practitioner such as myself who works in the CBD, it's very easy to send a clerk to the court with the original will, which meant that I didn't have this experience within our pilot, but I do know some of the other firms are in the pilot, and they had the experience where a party wanted to file a caveat against a grant, but obviously it was not hugely advertised as to which firms were participating in the pilot program, and so there were some practitioners who wanted to file a caveat against the grant that were too slow because they were relying on the usual 2 to 4 to 6 week time frame for a grant to issue from the court, and that simply didn't happen. Time frames now that it's available Queensland wide are evening out. It's still a really fast, streamlined turnaround, and it's been a really positive experience from our end. Although, as I said, after listening to Judge Riordan and Registrar Price speak, I'm a little bit, I think, jealous of the because e-filing's obviously been a really big part of the practitioner experience in Victoria for some time. So that is definitely something that I personally would like to see be embraced in Queensland, and perhaps with the success of the e-filing program for grants of representation, it will be rolled out elsewhere. The other thing that I just thought that I'd contribute to the conversation about today is to just give an update as to where Queensland is at with respect to the remote or online witnessing of wills and enduring powers of attorney. So unlike Victoria, who has legislation that has commenced from today, we're still operating under Queensland's emergency COVID response legislation, which has a very long name, and I'm not going to repeat it all here because I lost the screen that I had it up on and I can't remember the exact act name, but that legislation has recently been extended to expire on the 30th of September of this year, which means that practitioners in Queensland are still able to use, or testators in Queensland are still able to get the benefit of the remote witnessing requirements for wills and enduring powers of attorney. But at this stage, that will end on the 30th of September. I just thought I'd mention quickly as well, and that is because Registrar Price mentioned, I think there's been a number of requisitions or matters or informal wills. I think you said 0 out of 14 was the strike rate under the Victoria's emergency response legislation. I don't actually have the Queensland figures here, but I do know that one of the things that happened in Queensland was that the Chief Justice made a practice direction which empowered our probate registrar. If a will had been signed between, I think, the commencement of the pandemic and a particular date, which I believe was the 30th of September last year, so it's no longer operative. But if a will was signed within that period, then and there were certain other conditions met where it was really clear that testamentary capacity wasn't an issue. There weren't any other weird evidentiary issues that really properly should have been determined by a judge. The probate registrar is able to make an informal will order in those particular circumstances. So that was one of the ways that the Supreme Court of Queensland tried to help the public in this process. I don't actually know if that practice direction has been relied upon yet. I might ask the probate registrar. So well, coming back to the electronic execution of wills and the emergency response legislation, I would say that the Queensland profession is pretty much divided 50-50 as to whether that legislation should be extended and made permanent. There are a lot of concerns amongst some Queensland practitioners. I'm not including myself in that because I think that clients are now demanding services like this amongst other things. I mean, it's difficult to explain to a client why they can sign a contract to purchase their home electronically, but they cannot sign their will electronically. That distinction and understanding can sometimes be difficult to explain to a client, but as at yet, the Electronic Transactions Act still has a specific carve out in relation to the signing of wills and enduring documents. So I think some of the big concerns about making it permanent is the idea that that we don't want to be contributing to or promulgating or elevating elder abuse. One very experienced and well-known Queensland solicitor at the Queensland Law Society Succession and Elder Law Symposium, who's a very experienced practitioner, a very skilled interviewer of clients, was interviewing an elderly person, and it was only picked up right at the very end of the interview that there was actually someone else in that room that was there. Someone was in the room, I guess, feeding or assisting, and I'm using that word with quotation marks there because it was clear that that person was influencing to some degree the responses that were being given to the interview questions. I know that there are a lot of safeguard protocols that can be put in place. For example, can you turn your camera around? Can you show me, you know, who else is in the room? Questions to ask about who's in the room, etc. I do think that there is a concern amongst some Queensland practitioners that that's not, you can't substitute being in a room and closing a door and being certain as to who is actually in that room and who is actually having that conversation. I think that that the proper balance would probably look like enabling the legislation, and then that simply becomes evidentiary matters if these things do proceed to court about undue influence or if any solemn form proceedings arise as a result of the execution and the circumstances that it was made in. Another thing that is a really big difference to how between the Victorian legislation and the way things currently stand in Queensland is that we cannot use any sort of electronic signing platform. So wet ink signatures are required even whilst the remote execution procedure is being used. So for example, that can be quite difficult. For example, if I'm seeing a client, I need to email it to them or post the will to them or get it to them in paper because they actually need to affix. I need to be able to view them using the audio-visual technology, using like affixing their wet ink signature, or incorporate the use of a substitute signatory, which is also quite involved under the Queensland emergency response legislation, because if I were to be the substitute signatory for a testator, I would have to effectively find, about two other lawyers or one other lawyer to serve as a special witness, and in addition to the other lawyer as well. So you end up having more and more people involved in the execution process. If you're using a substitute signatory. I was really interested in your comment, Registrar Price, about how practitioners would possibly satisfy themselves as to how you would be like visually seeing them affix an electronic signature, because I think that's a really interesting evidentiary matter, because if I'm just using this Zoom conference as an example, Carol, if you were to share your screen and I could see a document, all I can see is a signature appearing on the document. There is no way for me to actually eyeball you clicking the mouse to put that electronic signature on the document. So I think there's some interesting evidentiary questions that I hope there's a decision sometime soon from Victoria so we can see what that looks like. I think overall, though, that that progressing this area of law in Queensland would be a positive thing to do. As I said before, from a client demand perspective, I also think that for as long as there has been wills, there has been fraudsters. No matter what time, no matter what century, there's always been people who have been trying to procure a will in an unscrupulous manner. And that it will just become a part of evidence in proceedings about the validity of wills. Enduring documents are also particularly, they're being scrutinised in Queensland in relation to the elder law context. So we've just had a slight amendment made to our emergency response regulation that came into effect last week or the week before, which was clarifying the timing of the placement of the wet signatures on the document. So there was a bit of confusion as to, so in Queensland, the principal signs the document, the witness has to sign the document in two places. And then the attorney, if once they're accepting the power that they've been given by the principal, also need to sign the document. And there was some concern about the timing of the placement of the signatures, as in if the principal has signed the document, but the witness hasn't yet signed the document, is it still open for the attorney to affix their signature before the witness has actually put their signature on the document anywhere? So there was, that was clarified, and the answer is yes, the attorney can affix their signature beforehand. The special witness, yeah. So
we've had some, no, that's okay. Forgive me for interrupting.
That's
we've had
okay.
some interesting conversations in Victoria about how we manage our probate and estate instrument documents as well. We did start with the pass the parcel method, which was last year, and we're somewhat grateful to have moved on, I would think. It does cause some complexity. It's interesting that you've raised the power or the attorney documents as part of your discussion this evening, because it would be remiss of me not to note that the power of attorney regulations have been updated in Victoria and now include special forms or updated forms that came into effect today. So those might be some documents that Registrar Price ends up having to manage or to see as part of her work as well. I think Judge Riordan also might see some of those, but far more less regularly. Chris, thank you very much for a very informative chat about the position of Queensland at this time. We certainly look forward to, in Victoria, to being able to help perhaps going forward, and keeping up the conversation with Queensland. And we've had some questions that have come through, and I think there's a couple that sort of cover the field, although there was one specific that I saw about affidavits being about the effectiveness and validity of affidavits if the affidavit maker is overseas and is making or the affidavit is being taken here. Judge Riordan, you would have seen affidavits that have been taken in those circumstances?
I'm trying to remember whether we've actually had, I would have thought, Carol.
The questioner is asking about the validity of the affidavit. I'll just pull up that. Andrew Woods of Woods Wills Lawyers asks, will new legislation enable us to take affidavits for Victorian matters from individuals located interstate and overseas? And of course, any opinion I might have about that would be, of course, subject to a far more senior view.
Yeah, well, I think your opinion is much more important. As Kate said, we're not very good at giving opinions. We're not allowed to charge for them anymore, Carol, so we don't like giving them.
Right, I see. Well, I can certainly understand how you might feel about that. Lee,
I think there's some very interesting cross-border jurisdictional questions there, because the emergency response legislation enacted in Queensland has actually specifically said that I can sign up for an enduring document, for instance, sign a Queensland form for somebody who is not present in Queensland, and that is a valid document. So, which I note is, I think, different to the Victorian legislation that came in today that makes it clear that everybody that's utilising that legislation needs to be within Victoria. Sorry if I've misquoted that, but
no, that's right. For wills, everyone needs to be in Victoria,
Yeah.
But the Oaths and Affirmations Act is silent in relation to where everybody needs to be. There's two parts of the Oaths and Affirmations Act that people might want to look at, and that's for who's able to witness affidavits when they're witnessed in Victoria, and then who's able to witness affidavits when they're outside, when the deponent is outside of Victoria. And then you probably need to make an assessment of whether or not you fit within one of those categories. But it is silent also on what is deemed the place of witnessing, whether that's the place where the deponent is or whether it's where the witness is. So perhaps something that requires a bit more research, Carol.
I think it is, Registrar Price. We might ask Andrew Woods whether we've satisfactorily answered his question. Andrew, if you'd like to put a comment in, or if you'd like to come on and have a chat with us.
Oh, hello. Thank you for that. Yes, I think it's still an open question, which was why I asked it. Quite a lot of people, whether it's in a probate situation or even litigation in the wills and probate area, we have clients that are overseas, and if it's possible to take those affidavits without dragging them elsewhere or sending them off to other notaries public in other parts of the world, it would be a very efficient use of time, which is why I asked the question. But I think more research is the answer, isn't it?
I think so, Andrew. The tentative view held by the EWOC is that it depends upon the legislation of the state where the deponent is situated and the domestic legislation. So in our example, if the affidavit taker was in New South Wales, or for want of another place, more luxurious, perhaps Italy or something, if they were in Italy, then if the affidavit maker was there and we were the solicitors witnessing the affidavit and issuing the oath, then for our purposes in Victoria, the affidavit would be okay on our end. It would just depend upon what's happening on the other end, if there's got, equivalent law. So it needs to be a little bit more refined. The unidroit principles are really of a commercial application, and so they probably need to be more broadened out into a more legal for a more legal application in litigation and the other ways that we use signatures and witnessing. But
maybe that's something that EWOC can make submissions about, like, one of the projects, submissions to the legislatures across Australia, the individual jurisdictions, to clarify all of those issues, or perhaps even introduce some uniformity. But considering the Uniform Succession Law project started in the early 90s and hasn't yet been implemented, that's a big task.
Well, we have uniform, roughly uniform electronic transactions acts, so we should be able to, deal with a smaller part, which is, affidavits and the like. So, Andrew, thank you very much for your question. Inez, are you available to have a conversation with us about what happened with medical treatment makers and in the Justice Act? So Inez Calwait from KHQ Lawyers has asked about the appointment of medical treatment decision makers and why they were not included in the Justice Act. And oh, we've got a question, a written question. Oh, several written questions. Did you want to come on live, Inez, or would you like to stay as you are? Maybe pop through an answer.
Hello.
There you are.
Yeah, I am sorry. I just needed to get ready.
That's okay.
Here we go.
We didn't catch you walking the dog this time, which, you know, is pretty good.
Yeah, that's right. No, I was actually at a funeral today, so I'm a bit rushing around. But
Sorry.
yes, that was my question. Whether there's any insight into why the medical basically powers of attorney medical treatment were taken out of this legislation, because of course for practitioners we kind of sell everything in a package. So the will, the financial power of attorney, and for better words, the medical power of attorney. And when because the medical power of attorney is not part of the legislation, it makes it kind of difficult from a practical point of view. I love, as I probably last time said, I really like this kind of legislation and would like to make more use of it. I live in country Victoria, even though I practice in the city, but I can see that it would be very useful for people perhaps with a disability, or people from country Victoria who can't travel to their solicitor to make use of this legislation. But if you are limited in terms of the sort of the three main documents that one signs, it kind of, in my eyes, almost defeats the purpose, because you would have to send the client out to find witnesses for the medical power of attorney in any event. So I'm just wondering whether there's any insight, what the particular reason is that the medical power of attorney was not included for the appointment of medical treatment decision maker, to say it properly.
I certainly can't speak for any contribution that the court made to the then bill, but as a stand-in contributor to the LIV Tech and Innovation Committee, I was able to participate in the work that was done around providing policy advice. And the position at the time was that a medical practitioner needs to be involved, and otherwise it's a policy decision that needs to be taken in the future. It's something that needs to be managed perhaps more carefully than otherwise wills and estates, or wills and other estate instruments might need to be, given the degrees of impairment that are experienced by patients who are in the situation of needing a medical, well, for want of a better phrase, as you say, a medical power of attorney. So it's something that.
Sorry, I'm not particularly, like, I'm not talking about the advanced care director, of course, only the medical power of attorney, which, I was just wondering. But thanks for that, Carol. That's interesting.
Yes. Inez, thank you. And Naomi Guyot has said she agrees 100% with all of your comments, but certainly the medical treatment area and sort of the medical powers of attorney, they need to be something that will be dealt with over time. Thank you very much for joining us this evening, Inez, and I hope all goes well for the rest of your evening.
Thank you.
That's okay.
That's really interesting that has been dropped from the legislation. In Queensland, we don't have the two separate documents. We use one enduring power of attorney document, and we can appoint people for personal and health matters and financial matters under the same document. So that's really interesting that that's been dropped.
Certainly is. Phil Hannenberg, who I understand is in the room, has asked if there's any difference between state and federal jurisdictions regarding e-signing. Perhaps Judge, you might like to talk to that question.
Caroline, I really just don't know the answer. Throughout the pandemic, for example, in terms of affidavits and court documents, there has been nobody who's taken issue with the validity, for example, of an affidavit by reason of non-compliance. And I think that's probably just been a Civil Procedure Act response to the issue that parties are generally mindful of the fact that we need the material. And frankly, if an issue was taken, I would normally just get the person who gave the affidavit to come online and to confirm that take the oath and confirm the accuracy of the document. So not much is achieved by taking the technical point. So I just haven't looked at whether or not the federal legislation is relevantly different to the state legislation, because it hasn't been raised with me.
Thank you, and apologies to all for my phone suddenly going off in the middle of our conversation. I understand that there's a difference with the Corporations Act and companies now being able to sign documents by electronic measures, in that they're no longer permitted to do so. The bill that was being moved before the Senate or before the federal Parliament got stuck at the Senate level and was only able to progress later in the year, as I understand it. So that leaves companies a little bit high and dry, as it were, unless, you know, Section 126 of the Corporations Act can be used for powers of attorney and deeds, but that needs to be further explored. I think more research around whether a court or well, definitely whether a court would find the use of a power of attorney signed electronically to be valid or invalid in relation to a company. That needs to be further considered before we could possibly approve any of that, particularly given the state of the delay that's going to come from waiting for the Senate to make moves on the current bill. We've also got a question from Peter Gould about recycling documents for DocuSign. If panelists could address that, if Peter's in the room. He says that he sometimes recycles a document through DocuSign. For instance, he says, if I can't have everyone sign at the one time or for the last endorsement on a will, so it's necessary by signatory 1 in the DocuSign session ends and I get the document. For signatory 2, I just reintroduce that document into DocuSign and have it signed by signatory 2. Does this offend any of COVID emergency regulations in Victoria? Is it legally offensive any other way? I think we don't need to worry really about the COVID regulations now, given that the Justice Act has taken effect. But certainly, Registrar Price, you might have views about a will being signed in that manner.
Yeah, I think the key is that it has to be, every signature has to be audio-visually witnessed, and it all has to be done on the same day. And how that occurs technically, whether you're using DocuSign, some other program, as long as you're complying with those requirements in relation to it being all witnessed on the same day and all actually being audio-visually witnessed, I don't think there's any issues with one document's like starting one session, ending another. And as long as everyone's satisfied that that's the exact same document, because that's the other requirement under the Act, is making sure that whoever is the witness is satisfied that that document that they're witnessing is actually the exact same document as what was signed initially by the testator.
Yes, if you can hear me, that was my
hello.
question. And I think Registrar Price has answered the question. I have been recycling a partly signed document through DocuSign, and then, for instance, having it for a will, having the final endorsement made in a separate session, with effectively a separate document, because it's the signed document has been completed in DocuSign and has been sent to me. I then put that document through DocuSign again and have the final endorsement signed.
Yeah, the requirements of the regulations is that it be transmitted, similar to that. So it doesn't matter how you transmit that, as long as you're transmitting the document and the person who's witnessing it is satisfied that it's the same document. So I don't see any issue with that, but you just need to carefully look at the requirements under the Act and just make an assessment there as to whether or not you're complying. But as I said, requirements under the Act are as long as you're satisfied that it's the same document, as long as it's all being done on the same day and everyone's audio visually witnessing the signing of that document, then they're the main requirements of the Act in relation to the validity of the document. And then there has to be one final document that's transmitted back to the special witness who then endorses that document, and that turns out to be the original.
Yes, thanks.
Christine Smythe, we might have you as a registrant under or with a typographical error, but I understand that Chris Herrald might want to have a conversation with you if you're available. Christine, if you could please put up your hand. You might not have Christine.
I don't know if she's online, Carol.
That's okay, thank you. Is David Lucas available, please? You asked about whether Redcrest pro forma documents will comply with electronic wills for lodging. Of course, Redcrest has two parts, Redcrest probate and Redcrest.
Yes,
I meant Redcrest probate.
Of course.
so there's two questions that you asked, David. The first one is in relation to electronic signing of wills and probate documents, whether they're mandatory or still optional, and definitely still optional. So you can still witness an affidavit in person, and you can still definitely witness a will in person. It's really funny, the other day I was putting out, we've got this very old excerpt from a newspaper that was done back in the 1950s, and it's just a picture of 3 people around a table with someone signing something and 2 other people looking on. And it basically just says, this is how a will should be witnessed. And I was making comment to Deputy Registrar Dunkley that it would be quite difficult now to do something similar to show how a will has to be witnessed. Now that you can do it electronically, it's not quite as easy to capture just in one picture. But certainly in terms of wills, they can still be done, in person, the old-fashioned way with a pen and pieces of paper, and the same with documents. However, it is mandatory to electronic file in the probate jurisdiction now as of 1st of July last year. So certainly you have to scan everything in and still upload it. In terms of the Redcrest documents that are produced, that's a standard affidavit, and that's everything that's required under the rules. If you were witnessing the affidavit electronically, you would need to alter that affidavit to make sure you're complying with the requirements under the legislation in terms of making sure it says that it's being witnessed via audio-visual, etc. And if you're exhibiting a will, you may need to make a little bit of an alteration there if it's a purely electronic will, because you'd be potentially exhibiting a USB that contains the original document rather than an actual physical paper document. So there are a couple of alterations you may need to make to the standard affidavit if you were doing an electronically witnessed will. But obviously we create the affidavit for the 99% of the, no, not probably 99.9% of the applications that come through. So there are always circumstances where you might need to make alterations to suit a specific type of application.
Thank you.
Thank you, Registrar Price. We've had a question about the best technology to use. And I would think that the court would not have a view about the best technology. And at this time, I'd have to say that EWOC doesn't have a view either. We are a one umbrella, everybody welcome organisation at this time. There's certainly some leaders in the field, but that will be the topic of another EWOC seminar. and it may be a seminar. You may be able to come in person, which would be very exciting for everyone. We've got a question from Carla Dunn of Plan First Legal to Registrar Price on how the electronic wills filed on USB will be retained by the court.
The USB would be retained. So we actually retain the original will. We keep it for a little while and then it goes off to the Public Records Office. Nothing will change. So that USB that's filed will actually be the document that goes to the Public Records Office as the original will, basically as the original document.
Thank you. There's been a couple of questions which I think that the Justice Act does address by amending the Electronic Transactions Act insofar as deeds are now capable of being signed electronically. The questions directed as well around corporations, which we talked about a little while ago. So if there were, I'll just check in on our questions from the audience, our Q&A at the bottom. And I think we might have answered all of our questions. Unless I might just give a moment for people to ask final questions of Judge Riordan and Registrar Price and Chris. Oh, there we go. There's a flurry. Maybe 6 does not make a flurry, but hey. Lucy Percy would, from Head to Heart Estate Planning, I believe, Lucy, would love to know if any participants are feeling confident to use it. As clients request. So Lucy puts a question back to the audience. How have people been experiencing online technologies? If anybody would like to take the opportunity to have a conversation, put your hand up.
As the only solicitor, well, sorry, other than you know,
okay.
But I don't think Registrar Price or Judge Riordan probably have any recent practical experience about that. I'm obviously only answering from a Queensland perspective, but I think it is definitely something that clients are asking for. If you're asking me personally if I'm confident using the emergency response legislation in Queensland, the answer is yes, I am, but I'm probably in a pretty unique position in that I have a pretty in-depth understanding of the creation of those regulations, and but yes, clients are requesting it. And the other thing that, and I'm not sure if the Victorian Professional Indemnity Insurer for solicitors has done this, but in Queensland, our professional indemnity insurer has actually produced checklists to assist people in using the regulations correctly, as in, have you done this check, have you done this check, have you done this check? So hopefully, if there are applications being filed in the Supreme Court, they're not, they will be found compliant with the legislation.
Thank you, Chris. Well, the Law Institute of Victoria has issued what they call a practice note. I'd like to rephrase that as a guidance note on the Justice Act, and it has been issued today, and it covers every section of the Act and provides a blow-by-blow about what to do with electronic signing and witnessing of all of the documents, and it deals with all of the phrases. It's a very helpful document that I imagine that many practitioners in Victoria will be able to use. I was aware of the Queensland guidance notes, and Victorian practitioners were actually using those as best and adapting as best practice very early on in the COVID experience in Victoria. So I think that might be all for this evening. I've had no further questions.
There's just a couple of questions in the Q&A session that I can probably answer very quickly.
That would be great. Thank you very much.
Teresa Catalano has just asked whether or not the statement under the new legislation needs to be inserted after the electronic signing has occurred, or can it be done before? This is a difference between the regulations and the Act. So the regulations, a lot of the reasons why the wills haven't been going through is because it had to be done at the time that it was audiovisually witnessed, but under the Act, it can be inserted beforehand as long as it's actually there. So you can create your will precedents to make sure that it says that it's being witnessed via audiovisual link before you actually do that affidavit. The other question is from Ros Notch, and that's in relation to whether or not any regulations have been made yet, and the answer is no. So at the moment, the special witnesses are those that have just been prescribed by the Act, and no regulations have prescribed any further special witnesses for the purposes of witnessing a will via the remote execution procedure. And the last one is in relation to someone anonymous who asked about some of the revoked omnibus regulations. Are those amendments still in force despite revocation of the regulations? Because I believe there were some that didn't make it into the Act. And the answer is no. So anything that was in the regulations has now been revoked, and it's only valid now if it's in the Act. So as of today, you can download the new Oaths and Affirmations Act from the legislation website. It's available even though the Wills Act isn't, but that is now the Act, and anything that was available under the regulations is no longer available to be utilised. You have to look at the Act specifically.
Thank you, Registrar Price. We've had a further question from Lucy Percy. Can that final statement by the testator be typed / confirmation? She'd like some confirmation that it doesn't need to be handwritten so that no printer is required.
Yeah, so the Interpretation of Legislation Act allows for anywhere where someone says that it's written. Writing means typed, so it can be typed. So the idea of the legislation is that it is a purely electronic document. There doesn't need to be any wet signatures. It can be all electronic signatures, and every statement that is required can actually be electronically typed into the will as well.
Jennifer, if you'd like to ask a question. Jennifer Butler.
Sorry, can you hear me now?
No, there you are.
Thank you. It was actually my question. Thank you for that answer, Registrar Price, in relation to the revocation of the regulations. From an interpretation legislation perspective, I had understood that if an act had been amended pursuant to subordinate legislation, such as in this case the omnibus regulations, that amendment to, and the example I've given here is the Oath and Affirmation Act, would not be revoked when the regulations were revoked, but that's not correct from what you're saying. So, for example, that section 32 of the of the Oath and Affirmation Act is no longer in force, and anything else that the regulation, any other legislation that the regulations changed, is no longer in force. Is that correct?
Yeah, so if you have a look at the legislation website, as I said, the Oaths and Affirmations Act is available there, the new edition. So that will make it very clear to you exactly what is now in force in relation to the Oaths and Affirmations Act, because it's a act as it's in force from today.
Great, I'll do that. Thank you very much.
Yep.
Well, I'd like to thank everybody for their questions. We might start to wrap it up. We have certainly enjoyed the panel's discussion this evening, and we thank them very much for their time in preparing for our conversations and for participating this evening. To Judge Riordan, thank you very much for taking time out of your very busy schedule. We know that the court's time is always very limited. And also, of course, to Registrar Price, equally we thank you, for your very informative and helpful guidance to practitioners in the probate jurisdiction. I think our takeaways about probate and electronic signing and witnessing is that obtain the new legislation, follow it, and use Redcrest Probate to make sure that we get through all of our applications very quickly, and we can assist the court in its in conducting its business. And Chris, thank you very much for joining us this evening. It's been lovely hearing about Queensland and how you are actually going to be catching up with us rather than us catching up with you. If there's anything we can do, just give a shout out, and us Victorians, I'm sure, will be very happy to lend a hand with policy making. But I do take your point that it might be a good step for all of us to get together as a nation and work out, well, how to uniformly have a deponent sign an affidavit and have it witnessed. Sounds like a very smart thing to do, a very commercial thing to do. I'd like to thank all of our wonderful guests this evening. If the panelists have any final comments, then they're most welcome to make them. But otherwise, I will say thank you very much for all of your time this evening, and we look forward to hearing more of your questions and to having some new members on the Facebook group for the Electronic Wills and Online Witnessing group. I must say as well, we are looking for members of our committee if you're keen. EWOC is certainly the place to be. At the very least, we have, a fun George Lucas styled name. What more could you ask for? George Lucas and electronic signing and witnessing laws across the nation and into New Zealand, I might add. We've had some New Zealand friends join us. We look forward to continue our partnership with the court if we're lucky enough, and with Mullens lawyers into the future. So once again, I'd like to thank you very much, everybody, and wish you a very good night.